These processes, we all certainly understand can be stressful. The circumstances surrounding them can be stressful, but the court process is not provided in order for folks to uh, become to treat one another disrespectfully, and the same goes for our staff. We expect parties, when they interface with our staff, to treat staff with absolute respect. That is what is required of each of us in our everyday interactions in these court proceedings, and frankly, in all respects as well. So, having said that, Mr. Bailiff, please call the case.
Yes, Your Honor. The matter before the court this morning is the case entitled In Re East Hill Road Wastewater Permit, case number 23AP186. This hearing was continued from 9 a.m. this morning due to a technical error. Appellant is represented pro se, Kayla Hope, and appellee Alexander Pojedenik is also representing himself pro se.
Okay, thank you very much. Ms. Hope, can you hear me?
I can, yes.
All right, and we can hear you, so please proceed.
Okay. My name is Kaylee Hope. I am a self-represented litigant in this matter. Thank you for taking the time today. I'm going to speak for a few minutes and I will reserve whatever time is left after that for rebuttal. The Environmental Division dismissed my appeal of the wastewater permit issued to Mr. Pojedenik because it appeared that I did not serve a copy of my notice of appeal on the applicant, according to the rules of procedure. I'll explain why the environmental court's decision is wrong, but first I just want to give you a brief overview of the timeline and the facts. So I filed my notice of appeal on October 14th, 2022. I've never done this before. Unfortunately, I misread the instructions the court gave me after I filed it. I thought it had said that someone was going to send me a list of interested persons, that I would need to send a copy of the notice of the appeal to those people. So I didn't send a copy of the notice of appeal to Mr. Pojedenik right away. And that was an honest mistake. On October 19th, Attorney Kane Smart entered his appearance on behalf of the Agency of Natural Resources and sent copies of his notice of appearance to me and to Mr. Pojedenik. And that's when Mr. Pojedenik learned of the appeal. Nothing else happened in the case until January 4th, when I filed my statements of questions, and the court scheduled an initial hearing for the end of February of last year. On February 7th, Mr. Pojedenik filed a motion to clarify my statement of questions, dismiss some of my questions as not being relevant, and set schedule for the rest of the case. We had our first hearing on February 27th, and that's when I first learned that I needed to send Mr. Pojedenik a copy of the notice of appeal. I did that on March 8th. We also had been in direct communication about a number of the issues in the appeal, sending more than 30 emails back and forth. And I had previously sent him the amended questions before that, but on March 8th, I just sent him everything just to be absolutely clear. Because that's when I first understood that I needed to do that. Unfortunately, my certificate of service at that time only listed the statements of questions because that's kind of where we were, and I wasn't really thinking that I would have to prove it. Or I wasn't, I had mentioned in one of my things that I had submitted that I had sent all previous filings. So that's why I didn't really specify it more than that. But anyways, on May 17th, the court dismissed the case for lack of service. The court noted in its decision that my failure to serve Mr. Pojedenik started out as an innocent mistake and lost innocence over time because I never served him, even after I learned I was supposed to. But by that time, I had served him, and the court didn't know it because of the issue with the certificate of service. So I'm asking this court to reverse the Environmental Division's decision for 3 reasons. First, Mr. Pojedenik waived any defense of insufficient service under 12H. Under this rule, if a defendant wants to request dismissal based on service issues, you have to do so in the first motion to dismiss or you lose that defense. Mr. Pojadenic's very first motion did not request dismissal based on service. It only requested that the court set schedule for the rest of the case to avoid future delays.
Didn't the environmental court find that the appellee did make note of his lack of service in that motion to dismiss?
Not the first motion to dismiss.
But in a motion to dismiss?
In a later motion to dismiss, yes. So secondly, my initial failure to serve him with the copy was an innocent mistake, as the environmental division said. As soon as I learned that I needed to send it to him, I did so. And it was unfortunate that the court didn't know that, because I did, and he knows that. And the court's decision there is premised on an incorrect understanding of the facts. Third, there was no prejudice.
You have 1 minute left, ma'am.
Thank you. Thank you. Yes, I was just going to say there's no prejudice to Mr. Pojadenic based on my initial failure to serve him. He participated in the appeal. He learned about it when he got Attorney Kane Smart's notice of appearance. If I had sent it to him, I would have sent it to him to the mailing address that was on the permit. So the same address that Attorney Kane Smart sent it to. And lastly, but certainly not least, I just ask that you not be swayed by the applicant's many inflammatory remarks and attempts to damage my reputation. I've really tried to avoid that, and I would ask that he do the same today. This is really about the state's issuance of a wastewater permit and nothing else. Thank you.
Okay, thank you. We'll hear from the appellee now. Please introduce yourself and then proceed.
Thank you, Your Honors, and may it please the court, my name is Alexander Pojadenic, pro se appellee in this case. The environmental court got it right. It properly dismissed the case based on sound legal principles under VRCP 12b-4 and 12b-5 and VRECP 5b-1. It found the appellant failed to serve process for 132 days. The continued failure to serve was not innocent and therefore prejudiced the appellees. The appellees sufficiently raised the issue of lack of service, and the dismissal was, quote, not only proper, but the appropriate necessary remedy. And such a dismissal was within the court's discretion given how the appellees were prejudiced in both their reliance in the finality of their permit and their loss of time to pursue a defense. The court—
Does it matter that it was an innocent mistake?
Well, I think what Judge Durkin argued is that it lost its innocence over time. And in fact, at some point, when I was in direct conversation with Ms. Hope, I directly asked to be served and reminded her of our pro se responsibility, at which point she said that it was a mere courtesy to be served, that it wasn't a legal responsibility if we're pro se. So I think that lost its innocence over time, as Judge Durkin found.
As it progressed, as the time went on?
Yes. But we were left completely unaware of the appeal itself for almost 3 months before we found out about it through Attorney Smart, not through the appellant directly by serving us. I guess back to my argument, this court should also affirm the dismissal. Doing so would be ruling in favor of justice and our rights of due process. At its heart, the original case was about upholding an already approved normal residential septic permit and therefore our ability to make a home on our property. But it was also about bad neighbors upset about a land purchase, abusing the wastewater appeals process. I want to make clear to the court that by affirming the lower court decision to dismiss the case on procedural grounds, no permitting or environmental regulations are being circumvented or violated. As to Ms. Hope's new wetlands claim, unsubstantiated wetlands claims in her rebuttal brief, not only are they not true, they fall far outside the court record and are in fact outside of this permit process that we're concerning ourselves with today. Before I get to the argument, I'd like to draw the justice's attention, however, to elements of the record that give context to Ms. Hope's appeal. The harm done in the case has been exacerbated by the appellant's behavior surrounding this appeal. This has included erroneous town zoning complaints, directly interfering with work on our property, multiple criminal trespasses for which she's now in a diversion program, and stalking us, which the civil court agreed and approved a 6-month protective order, all in an effort to deny us use and the enjoyment of our property. We simply wish to be left alone to live our lives free of harassment in an otherwise supportive and loving community of Plainfield, Vermont. The appeal before the court should be viewed as a part of this pattern of harassment. Back to the argument. In her brief, the appellant claims there was no prejudice, but her lack of notification and service for months was indeed prejudicial. We submitted ample evidence of financial and emotional damage sustained, and the court concluded similarly that we were prejudiced both in the reliance and the finality of the permit and the loss of time to pursue a defense. As for reliance, we took irreversible actions. First and foremost, my wife and I relocated to Vermont to temporary accommodations based on the belief our permit and our ability to make a home was secure. We were left completely unaware by the appellant that our permit was being challenged. In the intervening time, we incurred thousands of dollars in expenses in moving fees, storage fees, building materials, design fees, and we established contracts we would not have otherwise had we been notified as required. We could have remained in our existing home and waited for resolution had we known. There's also the incalculable emotional harm and burden that continues to reverberate today. We are not currently able to live in our home.
You have 1 minute, sir. You have 1 minute.
Thank you, Your Honor. We are not currently able to live in our home, nor do we have indoor plumbing as we await the results of this more than year-long appeal. The argument that the court abused its discretion when dismissing the case is incorrect since there's ample evidence of prejudice. As to the motion to dismiss, in her brief, the appellant also demands pro se leniency for her failure of notification, but if any leniency is to be granted, it should be in the reading of my initial consolidated defense motions, where I requested dismissal. The lower court agreed. I was prejudiced by Ms. Hope's lack of notification in part in that I was not able to seek timely legal guidance, usually available to all parties in the environmental court, before submitting my first motion. Yes, it could have been worded more clearly, but despite being hamstrung in receiving access to legal services, I stated all elements of the defense and asserted it. The court correctly interpreted my intention to motion for dismissal based on failure of service and notification. First, they determined that I sufficiently raised Ms. Hope's insufficiency of process in that first motion, identified the injustice, the missed deadlines, the total failure of notification.
All right.
Maybe my time is up. For those reasons and the reasons stated in the brief, I ask the court to affirm dismissal of the case.
Okay. Your time has expired. Thank you very much.
Thank you.
How much time does the appellant have, please?
Your Honor, appellant left 10 seconds remaining.
Ms. Hope.
Sorry about that. Sorry about that. Basically, the finality of the permit is subject to a 30-day appeal period. And so while I hadn't sent him that single document, we had been in communication with the questions and going back and forth. And so I really did not understand. The attorneys had told me that the main requirement was that the appeal was filed within 30 days. And that's why I said that. The existence of the Class 2 wetland is not new. It's in the record. It just didn't have much to do with the dismissal of this because that was about service. There's also an environmental investigation right now, and he's been told he has to get a wetlands evaluation before doing any work on the septic system.
Thank you very much. Thank you very much. Your time has expired. Thank you both for your arguments. Will you please call a conclusion of the hearing now?
Yes, Your Honor. That concludes